All right, the next case to come before the court is Sellers Smith versus Smith. Good morning, counsel.
Good morning, Your Honor.
Morning, Your Honor. Would you like me at the bench already, Your Honor?
You can just wait just a second. The court has read the briefs and is prepared to hear oral argument. I just want to lay out a couple of ground rules for you. You each will have 15 minutes, and the appellant can reserve up to 5. And this argument, as well as all of our arguments, are recorded and are broadcast on our YouTube channel. And so one of the things we don't want to do is use the names of children in this argument today, as well as, I would say, victims and other arguments, but I understand that this is a domestic case, but nonetheless, I like to say it. So we're ready to proceed when you are, and just let me know how many minutes you'd like to reserve.
Thank you. I'll reserve 5 minutes for a vote, Your Honor. May it please the court. My name is Kelly Torren, counsel for the appellant, RS, in this matter. The issues before this court are less issues of complicated fact or complicated law, and more an issue of my client's constitutional rights, both under the United States Constitution, the Ohio Constitution, and not only the law of Ohio, as well as this district. My client engaged in a domestic relations action with his wife, TS. They engaged in discovery, they engaged in negotiations, and ultimately resolved the case by an in-court agreement in 2021. However, the record does reflect that prior to that agreement, my client and his now ex-wife had separated almost 3 years prior. The parties both allege in affidavits and in the record that they separated December 29, 2018. The trial court had jurisdiction under Ohio law, and specifically section 3105-171A2, to find that there was a de facto date of separation pursuant to that agreed date in 2018, approximately 2.5 years prior to the date of divorce. That's all standard procedure. The issue before this court, however, occurred subsequent to that in-court agreement. The appellee, my client's ex-wife, submitted a proposed separation agreement pursuant to the trial court's order. Under Local Rule 2801, the appellant filed timely objections within 7 days of that submission. The case continued pending, the counsel came on, there was issues of necessary documentation, and in September of 2021, the appellee, for the first time, without previously serving any documentation on the appellant, submitted a proposed judgment entry of divorce, separation agreement, and shared parenting plan. Now, the issues that bring this case before this court is that proposed judgment entry and separation agreement had not been provided to the appellant previously, had not been reviewed by counsel.
That was different than the separation agreement that was submitted to counsel for the July 12th objection.
That is correct, Your Honor.
How was it different than what was submitted in July?
There was an attached personal property listing to be divided out of household contents, which included multiple firearms, some of which were inheritances, a firearm safe, as well as other household contents that differed from the personal property listing that was reached at the in-court agreement.
And whatever was submitted in July 12th, so it was different
Correct.
from how it was submitted on July 12th.
Correct.
Was there a judgment entry submitted on July 12th to object to, or sometime prior to those objections being filed?
There was not. Previous to the September 23 proposed judgment entry and a admittedly revised separation agreement, there had been no proposed judgment entry prepared by the appellee or served by her counsel to be objected to pursuant to any local rule.
Was the issue regarding the property and retirement accounts?
I apologize.
The issue regarding the retirement accounts and selecting the date of trial rather than the de facto date back to 2018 date separation. Would that include in both the July 12th separation agreement that was submitted and the one in September? Were they both the same issue at that point in time?
Yes, Your Honor, and the appellant had timely objected to the division of property under that in-court agreement.
There was no Rule 28 motion filed in July with with the separation agreement, I take it. Is that fair?
At that time, no, because it was just a separation agreement and not a proposed order. Under the trial court's original orders, the appellant was to submit a proposed judgment entry, the appellee was to submit a proposed separation agreement, but due to additional documentation from Social Security and offsets, a proposed judgment entry could not be submitted at that time. The first judgment entry was not served until September, which did include the same issue of division of property and retirement assets, which failed to account for a division of property on a de facto date of separation, and failed to account for an offset of the appellee's Social Security benefits as opposed to the appellant's pension plan. Those are-
Counsel, my understanding is in your original agreement, aside from all that, in your original settlement agreement, what you agreed to, that there was no agreement as to a de facto date of the legal separation, that being the date of the actual marriage termination.
That is correct, Your Honor. There was no agreement. This agreement was actually silent as to that fact. The appellant has contended in both the briefs and below that, however, the de facto date of separation is a matter of equity and well within the discretion of the trial court under 3105-171A2. The parties had agreed that that was a separation date. They separated both financially and physically. They did not engage in any marital relations. It was a less than friendly separation, to put it politely, and the issues between them had continued thereafter. They both retained counsel, instituted these proceedings, and it was a matter for the trial court to, in the silence of an agreement otherwise, find that as a matter of equity, it was fair and just to find that a de facto date of separation had occurred.
When was the agreement read on the record? Do you recall the date of that?
I believe it was June 9th, 2021. I may be wrong, but I believe that's the date.
So your review of the record is on June 9 when they got to the issue of retirement accounts and otherwise. They simply said they'd be divided.
Correct.
Pursuant to I don't recall exactly, I assume language divided. The marital portion would be divided, didn't say what the date of the marriage would be at that point in time on the record.
Correct. The agreement was that qualified domestic relations orders would be prepared by Hudro Group, or now I believe it's pension evaluators, that a third-party entity would prepare those orders and submit them to the court to be adopted and issued. The issues thereafter, once that proposed judgment entry was served for the first time and filed, was that less than 8 hours later, the trial court issued an order adopting that order, failed to allow the appellant to respond or even set forth any objections pursuant to the local rule. Under Local Rule 28.01, appellant was allowed up to 7 days to file timely objections, setting forth what terms and provisions of this now admittedly revised separation agreement and the first time served judgment entry of divorce failed to incorporate from the June 9th in-court agreement. Due to the trial court's quick adoption of the proposed entry, the appellant was substantially prejudiced because now his retirement assets that should have at least been offset at the very least with Social Security benefits of the appellee now were to be divided pursuant to a proposed entry with a different date of separation or a date of divorce and without any type of offset, providing the appellee with substantial windfalls.
The June date where they read the agreement on the record, there was no mention from Social Security benefits being set off, if I recall. Is that correct?
I'm sorry, Your Honor, I didn't hear your question.
The June date the agreement was read onto the record.
Correct.
There was no discussion of Social Security benefits at that point in time being set off in front of the court. Is that correct?
Correct. The agreement read into the record was silent on several of these issues. The trial, I apologize, go ahead.
So an order that you did not approve, it says that on the order, was signed as an order within 8 hours of the time it was filed. And
Correct.
so your bottom line argument is that you had no due process in making any kind of objection. Did you also try to remedy that with the court at the time?
We did. We filed a motion to vacate that entry. Timely, I believe it was approximately 12 days after it was adopted. We filed a motion to vacate. That was not ruled upon by the trial court prior to filing the notice of appeal. It was subsequently denied. However, that was appealed to this court. It was dismissed as a void order due to the within appeal, and as a result, that motion to vacate remains pending, but the trial court does not have jurisdiction to issue any order ruling upon it. As to, other than the due process argument, as the court has pointed out, Because of the factual objections and the timely objections that were filed, as well as a motion to vacate, appellant contends that he was entitled to an evidentiary hearing on his objections. Due to the silence in the record, silence in the agreement, as to any type of social security, de facto dates, and all these issues that were not addressed by an agreement or the trial court previously, he was entitled to an evidentiary hearing under the 8th District's decision in law. However, trial court, due to adopting an entry the same day it was filed, was precluded of that right. As to this court's holdings, and I see I'm almost out of time, so briefly, the issue of the local rules is mandatory. The trial court is bound by these local rules, specifically when due process is violated. My client was not even allowed to respond. The appellant wasn't allowed to say anything in objection to this proposed order prior to the trial court's adoption of said order, and he is entitled, as a matter of due process and fundamental law, to an opportunity to respond to these claims. I'll reserve the rest of my time for rebuttal, Your Honors.
Thank you.
Good morning.
Good morning.
May it please the court, Attorney Ralph McGargle for Appellee Tina Sellers. Appellant has contended that the entry as adopted by the trial court on September 23rd did not account for a Social Security offset of the appellee's Social Security benefits against the appellant's PERS benefits, but that is not true. It did provide for that Social Security offset. That provision for the Social Security offset is in fact the only difference between the entry as submitted on July 12th to appellant and the entry as adopted by the court on September 23rd. That and the inclusion of two lists of property that were provided at trial, that the trial transcript clearly shows the judge read as the parties were reading their agreement into the record and questioned the parties about. This case arises from approximately a year of divorce litigation, which is not unusual, ending in the parties reaching a global settlement on the day of trial, which is also not unusual. Parties read their agreement into the record in all of its essential terms, and then the court, as is often the case, ordered the parties to produce documents that reflect that agreement as read into the record. A separation agreement covering all of the terms of the division of marital property, a parenting plan providing for the parties' minor children, and a judgment entry decree of divorce that simply adopted those two documents and performed the act of the divorce itself. Appellee prepared the separation agreement and the parenting plan and promptly delivered them to appellant. Appellant fired his attorney at that point and hired new counsel. New counsel did not approve the separation agreement as presented. No objection was made to the parenting plan, and new counsel filed a motion with the trial court stating his objections to the separation agreement. The trial court heard arguments on those objections. Appellant ordered a transcript of the agreement as read into the record and provided that transcript to the trial court. The trial court had the benefit of reviewing both its memory and the transcript of the agreement as read into the record. Finally, appellee submitted a judgment entry, which admittedly was not provided on July 12th. I misstated in the appellee's brief that it had been provided, and when that was pointed out by appellant's counsel, I went back and looked and realized that was not. Regardless, that decree is a purely technical document. It says these people are no longer married as a performative speech act. It says we adopt the separation agreement and parenting plan, and it provides a very technical recitation of the support language for use by the Child Support Enforcement Agency in actually collecting the support. That's it. There is nothing in the actual decree itself that appellant is objecting to in this appeal. All of appellant's objections were the terms of the separation agreement, which, as I said, had been provided. It was different as adopted on September 23rd in the one circumstance that it in fact provided for that Social Security offset, but that did not operate to appellant's harm. That change operated to appellee's harm.
Counsel, the appellant seemed to argue, if I understand it, that the property, the personal property division, if you will, the guns and all that, was slightly different from July to September. Would you agree with that, or would you disagree?
I would agree that appellant has argued that that's true, but I would also say that, well, as a matter of fact, that was an extremely exhaustive and detailed list that was read into the record at trial. And appellant has not said what item on those lists does he disagree with. What item, as in the decree is adopted, is different than the items as set forth and read into the record on the day of trial.
Would you agree the sole difference is the issue of de facto or non-de facto?
I believe that is the meat of the matter, Your Honor. That is the essential difference. And what
Was the de facto issue raised prior to trial and prior to settlement, and an issue that was discussed and before the agreement put on the record back in June, if that's the correct date for the agreement on the record?
the first time the subject of the de facto date of the marriage was raised was in appellant's brief before this court. It had not been raised in the pleadings, it had not been raised by motion, and it had not been raised before the trial court on the record when the parties read their agreement into.
And it was not part of the July 12 objections that were filed?
It was not set forth on the document of the July 12 objections, but to be fair, though that document says I object, it does not say.
It was not a detailed list of objections, it was just a simple I object to.
That is correct, Your Honor. But I was not trial counsel, and so I cannot recite from my own memory what happened. I can only refer to the record.
Does the court have in the record the argument hearing that occurred after I seen July 12 and before the September decision? Is that part of the record before the court?
The actual transcript of that is not a part of the record. What is a part of the record is the motion to adopt the entry separation agreement and parenting plan filed by appellee on September 23rd. And in that motion, the appellee's counsel did set forth, this is the difference between this document and the one I submitted on July 12th. It is in this matter of the Social Security offset, and provides a recitation of what was discussed in those arguments and what measures were taken in order to address that discussion. No mention is made of the date of division. Counsel is correct, the trial court has jurisdiction to choose a date other than the date of the marriage through the date of the divorce. But in order to do that, trial court has to first make a determination that using those two dates would be inequitable under these circumstances. In order to make that determination, somebody would have to ask it to do that. It would not know to do that in a case where an agreement, a full agreement, was read into the record. Counsel had the opportunity at trial to say, we agree about everything but this. And so we read all of our agreement, and you, court, you decide this issue.
Well, I understand appellant's argument to be there basically wasn't a meeting of the minds. There was never an agreement placed on the record of what date we would be using for the termination of the marriage, be that the de facto date or the date of trial, like the statute would normally say, without being final de facto.
Your Honor, that is, I think, an accurate statement of what happened. However, the code provides for that. The scheme of the statute is section A2A says this is your default, date of the marriage through date of divorce. And then section A2B says, in that unique circumstance where the trial court makes a determination that it would be inequitable to use those default provisions, then the trial court can choose some other dates. But there is a default provided under the statute. If the parties were silent on that issue, the default simply applies. There's no argument that the court would even have understood that there was any possible reason to do anything other than what the statute provides for.
Doesn't that imply some form of actual taking of evidence and finding of fact by the court, which didn't occur in this particular case?
Yes, I believe it doesn't just imply that. I think it requires it. In order for the court to make an equitable determination that the dates of the marriage ought to be other than as provided as the default under the statute, the court would have to take some evidence to make that determination, or else it would be.
Well, they took no evidence one way or the other. Whether it was a de facto or it wasn't a de facto, am I correct in saying there is no evidence taken in this matter at any hearing in front of the court?
No evidence taken whatsoever, Your Honor.
And let me follow up with that, unless the parties agree.
Unless the
Would
parties.
have to make a finding, would make a factual findings if the parties agree to.
Absolutely, the parties, in fact, I think my understanding of the law is the parties would not even have had to mention that it was inequitable to choose other dates. They could simply have agreed to choose other dates. That in an agreement, the court will always allow the parties to do anything so long as it doesn't violate what would be substantial fairness or something that would work to the inequity of the child.
But when proposing a final order to a court with no input from counsel, whether that's the actual agreement, and then having the court adopt that in 8 hours, that'd be a difficult precedent for the court to set that can happen, that he doesn't get to approve, the opposite party doesn't get to approve the order, and the court doesn't make any time for objections. Wouldn't that be a difficult precedent for this court to set?
Well, Your Honor,
I mean, there could be anything.
yeah, I imagine that would be a difficult precedent. That's simply not what happened here. The actual documents that comprise the orders that appellant objects to were provided to him 2 months prior to that entry being adopted. And objections were in fact filed and heard. And so if that had come out of the blue, that would be a difficult precedent, but then you'd have to say, what is the harm? Not only does there have to be error, but there has to be harm. And even assuming arguendo there was error, there's no harm. The court could not make a determination, no matter what appellant wanted, the court could not make a determination that the argument had been made, or the evidence had been presented, or the agreement had been made at trial, that they should choose dates other than from the date of the marriage through the date of the divorce. It simply was not addressed. I would submit to this court it was not addressed because it was not contemplated. It was not in fact contemplated until this matter was already up on appeal.
As I recall, you also weren't the trial counsel who reached that agreement, is that correct?
That's correct, Your Honor. I was not trial counsel in the court below. And Your Honor, without additional questions, I think I've made my point, no point in belaboring that.
Any other questions?
Do you believe there's any requirement for a party to raise de facto termination in any pleadings or otherwise before trial?
I don't think that it's absolutely required. I think that regardless of any particular requirement that you formalize that request in some manner, you must at least tell the court at trial that that matter is in contention. If you want the court to then issue a decision where it makes a determination of those things.
And we had an agreement in this case, and there was no resuscitation in that agreement of what issues had been raised and resolved to go into the settlement agreement. In other words, no one said, hey, we had the issue of the date of the marriage and date of termination. We've agreed that we'd like to use date maps. That was not part of it.
That was not made, Your Honor, and I would submit that it is not a small issue. It is a material term that if you were going to have it be incorporated into an agreement, you would have to say that, because otherwise it would be very reasonable for the court to assume that since you did not mention it, you are using the default provisions provided by the statute.
So you would say that without there being a specific date mentioned, the court's fair to presume that the date is the date of trial?
Not only fair to presume, but required by the statute to presume. Thank you.
Thank you. You have your 5 minutes for rebuttal.
Thank you, Your Honor. I would agree with one statement made by Attorney McGardle during his argument in that a de facto date is in fact a material term.
Counsel, let me just start with that. Because if you didn't agree to that, how in the world did you ever agree to all the terms of separation, such as when the retirement would be divided? How would you ever come to any agreement without, that should have been the pivotal thing. So if you didn't agree to that, then you should be contesting everything in the agreement, right?
We contest the division of property in its total.
But what I'm saying is, you have contested that you didn't get notice. You are contesting that it should have been a different date, it should have been the date, but you haven't contested that you were not able to enter into this agreement because you didn't even have the foundation established.
Because if the court reviews the record and the agreement that was made, the agreement was to divide the marital portion pursuant to an evaluation by a third-party accuser. That third party, typically with the way they calculate it, is take the date of marriage and then a calculation based on the termination date of that relationship. Same
Right.
calculation the trial court would use. However, the issue then becomes a negotiation and back and forth between counsel parties as to what the terms of that entry would be. Because the record is silent, the court should also know, appellee didn't say at any point in the record, hey, we're not doing de facto. Didn't contest it, didn't raise it either. So to
Because
sit
it was
there,
a settlement agreement.
I apologize.
Because it was a settlement agreement.
Correct. So for counsel for the appellee to stand up here and say, well, appellant didn't say anything, therefore it's waived, it goes both ways. Neither party addressed it. The record is silent. And as to these objections as to the proposed entry in July, the appellant's objection, I object, the agreement isn't consistent with the record as read during the trial. There was no transcript prepared at that time. The subsequent attorney conference that occurred with the trial judge and counsel addressed the fact that we need the transcript. We don't actually know what the terms are. My firm is also not trial counsel, so we were not present. So we requested the transcript after the fact, but we had to get those objections timely filed within the 7 days of the proposal.
And whatever hearing occurred in front of the trial court judge after your objections, we agree that's not part of the record the day before the order.
I agree, Your Honor.
Was there any spousal support ordered in this agreement?
There was. It was just over 1,000, I believe. It was 1,081 a month.
And what was the duration?
87 months.
Did that duration take into effect de facto termination or not?
I do not believe it did, Your Honor. I believe it was effective on the judgment entry of divorce, but I would have to check that.
Thank you.
As to the issues of personal property and the division of property, the record reflects that the parties signed an agreement, a listing of the personal property and the household contents, and that's not what was submitted in September. So to say it was an exhaustive list, great. It can be a 5-page list of every firearm these parties have ever owned. It's not what was agreed to. They signed that listing. That's not what was submitted. Instead, counsel admits there was no judgment entry served. The revised separation was served for the first time when it was filed. The listing isn't signed, but it's close enough, so the trial court should accept it. That's not only difficult precedent for this court to set, that's directly contrary to this court's holdings in Ray State of Durkin, where it said when there is prejudice and a violation of due process, the trial court is bound by the local rules. The trial court is bound to afford the appellant or another party and litigant in the state of Ohio, in this district, to object. To say that we're going to set a precedent that, well, it's close enough. That's not only prejudicial, substantially prejudicial to my client, whose division of property and retirement assets he couldn't even object to, personal property listing that's still being contested. But that's also precedent that establishes litigants lose their right to respond.
Counsel, if we don't have the transcript, as Judge Stevenson was talking about, at the objections hearing, how do we know what really happened? Couldn't your client have gone in there and say, you know what, I agree to all this?
I thought maybe I misunderstand your question, Your Honor.
Yeah, if there's no transcript, how do we know what happened at that hearing? And maybe your client changed her mind and said, you know, I agree to this.
That was a Zoom hearing that occurred after the agreement. That hearing on the objections was not a presentation of evidence or testimony. That was.
But that's not my question. My question is, if there's no transcript there, how do we know what happened?
As counsel, I can set forth, as an officer of the court, there was no change in the agreement. We were counsel at that time. The objections that were addressed were due to the fact that because the trial court and in-court agreement was not transcribed at that time, we requested additional time to prepare those objections and to prepare an entry.
And you are over time. I'm going to see if Judge Stevenson or Judge Lanziker has.
No further questions.
No, it's a good thing you don't want any further questions. I can't even figure out who everybody is. So anyway, thank you very much.
Thank you, Your Honor. I appreciate the court's.
Counsel, thank you very much for your presentations to the court, and we will take the matter under advisement and issue a written opinion that will be sent to both sides, and we also will release it on the Supreme Court website. Thank you so much.
Thank you, Your Honor.